when we are teaching comparative public law to students, that is master's student, then we should focus a lot on independence of judiciary, that how judiciary works in different countries. And when I say independence of judiciary, then also you have to make this quite live, because independence of judiciary is a topic which can go on for even 1 year. So you have to try to make your student understand. And in LLM, we are not only teaching them theory, we are developing critical analysis skills also. So whatever we teach them, we should tell them that this is how these are the merits and these are the demerits, and here gray areas. So when we are discussing independence of judiciary, you can again use the word, and on board you can write the US system, and then you can come to Indian system, and then you can also discuss US system. So we know that in US the judiciary is quite independent, but then there are 9 judges, and out of 9 judges, if you see as on date, 6 judges are Republican judges are appointed, and they are known that they have the leanings to their appointee president. So when we see in US, Article 3 provides for the appointment of judges, and it says that President shall nominate and Senate shall confirm the judges to the US Supreme Court. And in US Supreme Court, the judges are appointed for life. So if you see, as on date, there are 9 judges, and out of 9, 6 have been appointed by Republican presidents. So they have Republican leanings, and 3 have been appointed by Democrat presidents. So they have Democrat leanings. And sometimes it may happen that there is a lockdown. There is no Senate confirmation. So there may be a case where, like when President Obama could not appoint 9 judges during last year of his presidency, because the person whom he nominated, Senate controlled by Republican members, was not agreeing to it. And then there was a claim that in the last year, President should not be appointing judge. But when Trump was in the last year of his presidency, he could appoint. Because in Senate they were having their majority. So whatever system you develop, that system will always have some room for manipulation. So in US, when you see that though judiciary is independent, and if we see judicial review right from judicial independent cases, Madison versus Marbury, and then later on so many celebrated Roe versus Wade. But then we see also last year, you all must have seen a huge controversy wherein the Texas legislature enacted a law that is Heartbeat Act of 2021. In that act, they told that the Republicans are more conservative and Democrats are more progressive. They support women rights and LGBT rights and black rights. They support immigration and a lot of freedoms. And on the other side, the Republicans are more conservative. They don't support all these rights. So Texas legislature is controlled by Republican party. So they enacted a law that beyond 6 weeks, abortion will not be allowed, because they say that beyond 6 weeks, the fetus in mother's womb develops heartbeat. Now, this created a lot of issue, because in Roe versus Wade, it was held by US Supreme Court that women has autonomy over their body and they can abort the fetus up to 24 weeks. So this matter went to US courts, and it was known well in advance that US court, out of 9 judges, 6 are Republican leading judges and 3 are Democrat leading judges. So judgment will come supporting this act. And same thing happened. When judgment came, then we all know that there was a lot of opposition in Planned Parenthood versus Casey. US Supreme Court told that the US Constitution doesn't mention abortion rights anywhere, so we will not interfere here with the legislature. And if you contrast this with the US situation with Indian condition, then we have MTP Act 1971, and that act was amended in 2021, and the termination of pregnancy was Parliament allowed even up to 24 weeks in certain cases. So this is how judiciary plays a role. So judiciary, when Indian Constitution was being drafted, there was a lot of debate in Constitution Assembly that whether we should go for due process of law or process established by law. Because if we see Indian Constitution Article 21, it provides for that no one shall be deprived of his uh, uh, life and personal liberty, except right to life and personal liberty, except by procedure established by law. And if you see Fifth Amendment and 14th Amendment of US Constitution, they explicitly provide for that no one shall be deprived of his life, liberty, and property except by due process of law. So the controversy was that should we Indian Constitution adopt due process of law, or should we go for UK like where Parliament is supreme? That is, if Parliament establishes a procedure of law, then that goes. So after a lot of debates and discussion and inputs from leading jurists of that time, the Constitutional Assembly went for that procedure established by law, because they thought in their wisdom that if we go for due process of law, a lot of cases will go to court, and Supreme Court may sometimes become third chamber of the Parliament. And even Nehru once remarked that we don't want a Supreme Court which becomes third chamber of the Parliament, which has veto power over the laws. But as we know, the subsequently in Menka Gandhi versus Union of India in 1978, Supreme Court told that no law can be arbitrary, and law has to be just, fair, and reasonable. So in a way, they brought this due process by this judgment, and after that, many judgments Supreme Court has exercised its power of judicial review under Article 13, under Article 136, under Article 226. High courts have exercised, and then under Article 142 they have exercised their power to judicial review all executive and legislative actions, and many laws they are declared as unconstitutional. And the biggest law which came under a lot of scrutiny was Supreme Court Advocate on Record Association versus Union of India 2015 in the month of October, wherein five-judge bench led by then Chief Justice of India, Honorable Mr. Justice Kehar, they declared by majority of 4-1 that Collegium shall continue to appoint judges, and only one dissent of Justice, Justice Chalmeshwar was there, who told that no, this collegium appointment is not constitutional and it's not fair. But then this was the judgment which was, not appreciated by many, because appointment of judges is a very crucial. ये क्यों निकल रहा है बाबा? मैं तो उसको टच भी नहीं.
ऊपर लगा दो, ऊपर और ऊपर कर दो.
ढीला है शायद.
अगर आगे पीछे बैठे हिले ना. हाँ, वहीं से. It's very crucial आप कह रहे हैं.
So in any independent judiciary, the judges play a very big role, and their appointment impacts the complete journey of constitution of any country. So I was telling you, when you are teaching this subject, comparative public law, please focus on this issue, that how judiciary and how appointment of judges plays a role. So I told you in US, when we have out of 6 judges who are appointed by Republican president, and the system in constitution is quite good, that president shall nominate and senate shall approve, and senate shall confirm, and there is a live debate which goes on. But what will happen if president and senate both are enjoying from the same party, and senate enjoying majority support of that party? Then this check and balance is not working. Similarly, in India, we know that judges are appointed by collegium now. And though personally I feel that collegium appointment is nowhere mentioned in Article 124 or 217, but it is right now the only method of appointment. But we see a lot of controversy in appointment of judges. And if you see judgments also, if you contrast maybe before 1993 and now post 1993 judgments, most of the time people feel that the judgments are quite pro-establishment, which is which should not be the case. Or when you find that people's aspirations or constitutional mandates are little different than what judgments people are expecting, which are coming out. So when you discuss this subject, please emphasize more on independence of judiciary and how we can make it further independent. Because right now, the US system, the Indian system, somehow judiciary is not so independent as it should be. Because unless we have judges who are independent, who are courageous, who are fearless, they till then you can't have a constitution working, because lastly the last word is with judiciary. And if judiciary is not competent, or cannot call a spade, or cannot rise to the occasion, then this constitutionalism won't be so much effective. So to my understanding, when you teach this in comparative constitutional law, please pay more emphasis on role of independent judiciary, how constitutions of world have provided for independent judiciary, but how this is not happening on ground, and what you can and then you can always suggest that how we can make systems which ensure that judiciary is independent, not what it is right now. So you see the words of constitutions, mostly they start from "we the people of United States of America" or "we the people of India." So I think we the people are the soul and heart of any constitutionalism. So we the people should take a call that how we can make judiciary more responsive, more transparent, and the thing to my mind it starts right from appointment of the judges. And the appointment of judges in India, you all know, is a complete opaque system. No one knows how they are appointed, and what are the merits, what goes. At least in the US, there is a live debate. Though they also get after debates also, whatever is decided is done. But at least there is some semblance of openness. So I would think that in India, first of all, we should reconsider appointment process. It should be more consultative, more meaningful, because if judges are appointing judges, then certainly there can be a lot of apprehensions, and then there should be check and balance in appointment system. It should be more open, more transparent. Let people know who are going to be appointed, what are their merits, and why others are being left out. Unless we have openness in the system, people will have their apprehensions, may be genuine, may not be genuine, because Indian judiciary, by and large, has helped nation grow faster, but the pendency, more than 40 million cases pending, and people making rounds of the court, this is not a good state. So any constitution, if it is not ensuring speedy justice, to my understanding, is failing in its basic mandate. And here, judiciary is going to play a big role. Right now, what is happening, I feel that judiciary is saying that executive is not providing them sufficient infrastructure, and executive is saying that judiciary is not somehow making its all efforts to ensure speedy justice. So whenever you're teaching the subject, try to relate this subject with the day-to-day lives of the people, and ask the student that they should go to courtrooms, or they should meet litigants, judges, advocates, and they should make their findings. What are the reasons? And they can come up with some solutions. So as I told you, this subject should help student, in their critical analytical skills, so that they see what are the provisions, they see how they are functioning, they compare it with other countries, constitutions, their systems, their theories, their institutions, and then they compare and contrast, and in the end they evaluate as Bloom taxonomy demands. That last stage of knowledge creation is knowledge creation and its dissemination for improvement of the system. Thank you very much.